Well, I'm going to have to do it individually because I have to do the orders of protection.
Okay.
So,
Is this okay?
proceed. All right. Record should reflect that Mr. Oliver is here with his client, Mr. Orkin. The people are represented by Assistant District Attorney Jordan McNamara. Okay, this was on for final pretrial. As the policy is in this district, that once that jury gets ordered up, it becomes a fair trial situation, absent any exigent circumstances. Was there a final offer conveyed?
Same offer, Judge.
Which is different from what was before?
Yes.
Right, so the offer was plead on 2 disorderly conducts, conditional discharge for a 1-year period, a 2-year order of protection. Again, it would have the terms that I've just been outlining. I don't know if you heard those terms that I've added in here.
I did. Did you?
Did you heard? Okay. And surcharge of $125. Counsel, does your client wish to avail himself of that offer?
No.
Okay, I will set a trial date then. Usually a month ahead of time, I'll send out my standard trial letter along with the copies of the proposed jury instructions that I use. Do you have an email that we can email it to you?
I have my staff does, but I'm not computer literate. I have fax.
I mean, we can send it out to you. It's just the jury instructions are like that, so.
That's fine.
Okay. All right, then we're looking at.
I'm not computer literate, unfortunately, but my secretary is.
How many clients do you have?
4.
4. I know there's an issue that's coming up with Mr. I'm trying to remember the other gentleman's name.
Salisbury.
Mr. Salisbury, because he has 4 defendants.
Does he?
Or was it you? I'm trying to remember.
He has,
I think
Judge
yes.
Kramer and Marianne Brady.
All right, who was the one that wrote for me to reconsider?
That was
That
me,
was-
Judge.
Okay. All right. I guess the first thing I want to deal with is there's some motions that Mr. Oliver brought here by letter.
Sure.
Have you received a copy of those?
Yes, I do.
So, Judge, I did receive the discs from Mr. McNamara subsequent to the letter, so I'm going to withdraw that.
Okay. So the only issue then, motion you're making is for me to reconsider the consolidation of your 4 defendants?
Yes, Judge.
And are we sure that all 4 of them are going to reject the offer?
Yes, Judge.
Do you want to be heard on that?
Is that the motion to consolidate?
Yeah, for the 4.
Just so the court's aware, what happened with the CDs was I had sent what I thought were working copies of CDs down. They didn't work. Eamon called me, who I actually talked to today too. He called me and said, hey, they're not working. He left a message. I had found out from someone other than him that the exact same copies that I had made didn't work. So when I found out from that person, I sent those CDs down. So as he was calling me, they were going in opposite direction. That's what happened. And then the letter, you had sent the letter probably the day before you got my CDs.
Right, he's withdrawing that
Sure.
motion.
I just wanted to make it clear for the record. Yeah, Judge, I still have concerns about trying all 4 defendants together. And my concern is, again, that there's a possible prejudicial effect that trying these defendants together in this case can have on one another. And that's the reason for my concerns with a consolidation of the trials is that effect. So testimony that they might give, one person might exercise their right to remain silent, another person might testify and inculpate their fellow defendants. So that's my concern with severing.
That was, counsel, that was one of the major concerns I had. The other concern I had, having gone through consolidated trials that were non-jury, I think you'd agree there's a difference between a jury and a non-jury trial.
Yes.
A lot of what went on in those consolidated trials, I can't allow in front of a jury. I mean, not only from the perspective of the defendants themselves, but also the people in the audience. It's going to be a different situation because we're in front of a jury, and I'm concerned if I allow the consolidations, it's just going to be prejudicial across the board. But I'll hear what you have to say if you feel differently.
Well, judges, I'm sure you're aware, consolidated trials are basically the rule in New York State. People are tried with they have different charges. In this case, these four folks, my clients, they know each other. They're previously acquainted. They came to DeWitt on April 28, 2013 in order to participate in a demonstration against using drones to kill people, particularly innocent people. They're charged with the same offenses. They're charged with disorderly conduct and obstructing governmental administration. They all came with the idea that they were going to demonstrate against the use of drones. They're all basically charged with the same type of criminal transaction, which is blocking traffic, so far as I can determine.
Do we know, and I know we haven't gotten to the Sandoval issues in Molyneux and Ventimiglia, but do we know what the records are on each?
I think each of them have previously been arrested for exercising their First Amendment rights.
Right, and if I were to allow that on it, and one of them were to take the stand and the others, it may prejudice the ones that didn't take the stand, correct?
Judge, I think that the records of my clients will exonerate and exculpate them rather than prejudice them. They've demonstrated against Jim Crow laws. They demonstrated against the war in Vietnam. They demonstrated against racial discrimination. They demonstrated against gender discrimination.
You do
The
realize,
things that they demonstrated against in history have come out to be that maybe they were right.
you do realize there are people out there that don't agree with that position that may be on my jury.
I do. I do, and my clients do. And they're, I think if they're willing to talk to you about that.
I mean, you may have a situation where somebody may be on the jury that may convict them despite the instructions I'll give them, just for the fact that they do protest on so many different issues.
I don't think that's going to change whether they're individual or joint trials. And you do instruct the jury that they're to consider each defendant individually, and the Court of Appeals in thousands of cases has ruled where defendants wanted to be tried separately and they weren't. The Court of Appeals has ruled that joint trials and the jury is presumed to be able to follow those instructions. I don't see why this would be any different.
And my reluctance relative to the whole situation turning into, sorry for using the word, a circus, because it's happened before. I basically, I've allowed things to go on in the context of a non-jury situation because I can separate myself from it, whereas a jury may not be able to. For example, the applause, you've been here on the other trials.
I haven't been, but
Okay. The problem is, that's all gonna, if that happens on these trials, if I allow this consolidation, you understand it's gonna chop up the trial. I may have to, you know, have people removed from the courtroom for not being able to, you know, maintain the courtroom decorum.
I instruct my clients not to talk in the courtroom, and I think that they abide by that.
Because I'm not gonna let that become prejudicial to any of the defendants.
Well, I can appreciate that, but I don't think that my clients are not going to engage in clapping or anything like
Yeah,
that.
but what about the fact that if there's people in the audience that are, you know, doing the applauding, the whatever, the accolades, I'm gonna have to stop the trial, and I'm gonna probably have to remove the jury while I remove people out of the courtroom. It's gonna chop up the trial.
But that's going to happen whether,
Well, so far it hasn't. When I've done one single trial now, and it went very smoothly. I just don't want to prejudice your clients, and that's what I'm concerned about.
but with regard to audience, you know, violating the orders of the court officers, things like that, you know, all I can do is tell everybody that we know in the audience that you shouldn't clap, and you shouldn't intervene, and that that's counterproductive. And if you have separate trials, it's going to happen anyway, except it'll happen 4 times instead of once.
Here's what I'm going to do. I'm inclined just in this specific situation to allow it to be consolidated for your 4. Okay? I've made sure that you understand, and have you made sure your clients understand the dangers here and the risks?
I think I have, Judge.
Okay, and on behalf of your clients, they're willing to accept that risk?
Yes, Your Honor.
All right, so I'm going to consolidate for trial purposes. And the names of your clients are,
Ms. Rice?
oh, wait a minute, Bryce we had scheduled already.
Yes, Judge. June 16 and 17.
But I'm telling you up front, if it starts turning into a problem, you know, we're going to go backwards with this decision. I mean, that may mean I may have to mistry it and go to a new trial, but
I certainly will advise my clients, and I believe that they will conform to the best expectations of
you realize by the consolidation, you're also limiting your preempts.
yes.
Okay. All right, Orkin, Rice, who else?
Ms. Pleune
Barfield and Pleune.
and Ms. Barfield.
All right, did we already schedule any of the other ones?
We had months tentatively mentioned, but no dates.
All right, the only one that was scheduled was the Rice one, right?
Yes, Judge.
Which was in June,
16.
June 16 and 17.
Yes, Judge. And I think just, you know, since if we do consolidate, it's probably going to take a little longer than 2 days.
Why?
Well, I mean, my clients are probably going to testify, for one thing.
Okay,
We order a jury for that week yet?
we didn't yet.
Is it possible to move it?
Yeah, I'm gonna have a problem with going to a 3rd day there. And I've got trial schedule all the way out to next March now.
I'm just trying to be realistic.
No, I agree with you. There's the reason I want to move it is the day after.
I almost now have to go to, if we're gonna do this, to get 3 days, I need March 2015.
Is that a problem?
No.
That's not a problem for us.
All right, so Tuesday, Wednesday, Thursday combo is what we're talking about, or we're talking about Wednesday, Thursday, Friday combo?
Tuesday, Wednesday, Thursday sounds good.
Tuesday, Wednesday, Thursday, I think is better.
Breaks up the week a little bit.
All right, you want to do 17, 18, 19?
Of what?
March.
March?
And this 2015, on the first day, we'll start at 8 o'clock in the morning to 9. We'll do the preliminary issues, and I'll send out a trial letter that I usually send out a month ahead of time. We'll go to 4:30 each day. Continue if necessary.
Now, Judge, you had granted my motion to have the preliminary hearing at least, if it was 3 days before the beginning of the
Oh,
trial.
you mean the Sandoval?
Yeah. So we had that for June.
I gotta put in, wait a minute, let me put this in.
It was June 5th. The Friday. I think it was a Friday.
Yeah, we had it for June 5th, Judge, at 3 o'clock.
So I've got to do that, I got to move that too.
What'd you do?
I wish you pushed the button.
Burn? Huh?
That's St. Patrick's Day, right? We're gonna be here.
Is that what it
Black
is?
America.
Try my best.
Oh, wait a minute, did I put this on St. Patrick?
March 17th.
You want me to back it up the week before?
No.
or-
No.
We'll all wear green, I'll wear a green tie, Judge.
You know, the jury may have a problem with that, you know that.
Well,
I'm just pointing that out. Depending on who's in that jury pool.
maybe they'll be in a good mood. Who knows who it'll benefit?
Or they may be angry that they're not out doing something else. You sure don't want it backed up the week before?
Sounds good to me.
But back it up? You want to go to March 10th, 11, 12?
It doesn't make any difference to us.
I'm just thinking the people in that jury that are going to be ticked.
That's fine, Judge.
So
fine,
back
right?
back up to 11, 12?
Oh, I'm at 12.
11, 12,
Some
13?
diehards.
10, 11,
10,
12.
11, 12.
I once served on a jury, I didn't complain, so, 20 years ago.
10, 11.
All right, so how many days do I have to back it up for the Sandoval then?
I think it was, the statute says at least 3 days, but, a little extra before is fine, whatever.
Do we need that?
Yes.
Maybe, I don't mean extra time, but I mean 3 days.
Some of
because
this,
we're
some
gonna
of
come
this
up
may
from
affect the
where we
DA
are.
downstairs. I haven't been watching it, so
That's fine. We'll figure it out.
I can could do it on the 5th. March 5th work for the Sandoval?
It's good for me.
You can just send out letters on notifying a dates.
Yeah. And you want to, what time do you want to put that one at? You want 5 o'clock?
3?
3. We had the other one at 3.
4?
You want it at 3?
Let's do
3's good.
3 o'clock, okay, and March 5th, 2015. Again, I assume, I don't know if it's gonna be me or Judge Jokel handling the trial, so we have yet to split everything up. So, all right, and lastly, I'm gonna reissue the order of protection.
Judge, before you do that, can I just ask a question?
Sure.
Do you want to read it all, each of Mr. Oliver's defendants at the same time, so maybe we
Yeah,
don't
that might
save
be,
time.
do you want me to